More breaking news right now. The Trump administration has asked the Supreme Court to allow the deployment of National Guard troops in the Chicago area. For more on this, we are joined live now with our legal analyst, Irv Miller. So, Irv, this is an emergency appeal, and so far this case has worked its way up through the lower federal courts. Did you expect it to eventually get to the Supreme Court?
Absolutely. There was no question that from day one that the federal government was going to take this from the district court, the Seventh Circuit, and then eventually to the United States Supreme Court, which they've just done within the last hour.
So how often is it that the Supreme Court would weigh in on issues of national emergencies, national security? Do you think that this is something that's quite rare?
You know, I think in this particular case, it's somewhat unique because we have conflicting decisions between the Seventh Circuit here in Chicago and actually an appellate court out in California. That's the type of case they will readily take. And I suspect they will issue some order either affirming the Seventh Circuit and allowing Judge Perry's order to stand, stopping the National Guard from deploying, or the opposite of that. But I think they will make a decision on this particular case because of the split in the circuits.
Well, good evening, America. This is Stuart Ryan once again with breaking news in the Trump deployment case, as the Supreme Court has surprisingly agreed to hear another emergency application from Trump, and it has asked for further briefing from the litigant parties on the issues. What is in question is Trump's improper invocation of 10 U.S.C. Section 12406 to rationalize the deployment of federalized National Guard and other troops into the streets of our cities.
Hi, everyone. Harry here to talk about big doings at the U.S. Supreme Court. Even though it's just a written order telling the parties to brief another question, this is in the all-important Trump versus Illinois case, where the court now has before it the question of the basic power of the president, as asserted by the administration, to federalize the National Guard, and that's what's happening in Portland, in L.A., in Chicago. He's promised in other basically blue cities. And I've been hyper-focused on this case because of its prospect that the Supreme Court would green light a measure of deferential review to Trump. And it would have to be deferential indeed to permit this authority, because the bases for it are factual predicates that just don't exist, it seems to me. So there are three ways that you can deploy this statute for a president. One, not at issue, is we've been invaded. The second is there's a rebellion. So part of the fight is, is there a rebellion? I've, in this context, talked a lot and really extolled the opinion of Judge Immerget in Portland, because she accepts the view that I think the Supreme Court may well, and in any event, the Court of Appeals above her has said she must, that you defer to the president. But she then went on to the critical next step of saying that doesn't mean that you just roll over for submissions that are wholly, in her words, untethered to the facts.
Harry Littman gives us pretty good initial breakdowns of what's at stake in this Trump versus Illinois matter, where the Nazi president Trump has sought to deploy these troops into Chicago, and I offer kudos to Harry for these efforts. We also hear a bit from lawyer Irv Miller, who chimes in from Chicago. But here's the real news. I've just finished reading Georgetown law professor and constitutional scholar Marty Lederman's fantastic amicus brief to the Supreme Court in this case on the issue of Trump's unlawful deployment of troops to Chicago that is going to be heard by the court on an emergency application after they get briefed again by the parties, and I believe there's a very early date on that.
Yeah, no, I know you were talking about it could go either way, but considering the makeup of the court right now, the conservative majority in many cases have ruled in favor of Trump in other issues. Do you think it's more likely that they would allow him to deploy troops?
You know, I think it's an even question right now. And you have to understand one other factor is that the one Supreme Court justice is like in charge of the Seventh Circuit. And that justice on the Supreme Court right now is Amy Coney Barrett, whom Trump appointed. She, I suspect, when she reads this, she will not make a decision herself. I think she will refer to the entire court. And the government, the federal government, is asking that there be an administrative stay. In other words, just make a decision without hearing from the other side. I don't think that's going to happen. I think they'll give the state of Illinois and the city of Chicago time to respond, and then there may be a ruling on an emergency situation. But I suspect you may not get a unanimous decision. I would be surprised, as you suggested, but I think you're going to see in a case like this, you're going to see dissents as well as concurring opinions. I don't think that all seven will agree, all nine will agree on this particular issue.
Professor Lederman completely shatters the Trump case and does so on an extremely narrow consideration of the utilization of 10 U.S.C. 12406 that demonstrates the invalidity of the statute based on a textual analysis and strict language of a necessary component or element enabling the statute's invocation. It's remarkable. He makes it clear that the court need not explore the viability of any of the three elements or prongs of the statute, one being invasion, two being rebellion, three being the federal government's inability to execute law. So, having done that, he points out it's because of the use of the words regular forces at the front end of the statute, backing his legal analysis up with a historical review of the strict meaning of the term that is surely overwhelming. His reasoning, which is extremely convincing, is that Trump, not having regular forces in place required by the law to judge and determine whether or not any of the three prongs exists in fact, and might satisfy the statute by their arguably preventing these forces from executing the laws, he cannot bring in any National Guard troops because he believes that the regular forces cannot execute the laws if they were never there. He explained this much better than I can. On page 18 of the Amicus Brief, he sums it up much better than me. And I'll read from the brief. It's easier. The amicus has not been able to identify any cases until this one in which the precondition described by the JAG Corps, the Judge Advocates, whatever that is, JAG, was not met, in which a president called forth National Guard units or members pursuant to 124.06.3 or its predecessors, to help execute federal laws without having employed troops from the standing military services and without having determined that such quote-unquote military forces were quote-unquote unable to adequately ensure the execution of those laws, because President Trump has not used regular military forces to assist or protect ICE in the Chicago area. He cannot, and he has not, determined that the executive branch would be unable to execute any federal laws with the aid of such regular military forces. Moreover, on any plausible understanding of what it means to be unable to execute federal laws, it is difficult to imagine that the president would be unable to ensure faithful execution of those laws if he were to first deploy regular military forces to assist ICE, assuming a sufficient number of such forces were available to perform that function. For this reason alone, the applicants, Trump, are unlikely to prevail on the merits of whether Section 12406(3), paragraph 3, precondition was met in Illinois. It's brilliant. After my reading of the brief, I'm convinced that even this Nazi majority Supreme Court will have to decide in favor of Illinois without having to reach the merits on the broader concerns of facts and the factual record, or the actual legal issues other than the ones that I've just pointed to involved in the dispute and the invocation of the law. It is nothing short of a fantastic legal piece of work. I'm so impressed. If this happens, we'll have a victory of sorts, or at least a temporary respite from the Nazi onslaught, but there lies a larger threat ahead from which we may not recover. Moreover, should Trump invoke the Insurrection Act, having failed with 12406, we are going to be in a world of hurt, because its language and it itself seems to be the one exception to the Posse Comitatus Act, and it is much broader in scope and vaguer in concept, and in its grant of extraordinary executive power to a president than does this failed 12406. The Act has three elements, Chapter 13, Section 251, 252, 253, that define the Congress's derogation or delegation of power to the president in dealing with his beliefs or judgments as to insurrections, conspiracies, mere obstructions, and so forth, without questioning his authority to act or even indicating possible judicial review of the statute or his actions. And incidentally, it's so broad and its language so vague that it might very well violate the First, Fifth, and 14th Amendment rights of all citizens to assemble, speak freely, and protest against the government and any of its laws or policies under our guarantees of the U.S. Constitution.